Okay.
What are we recording?
The meeting. Hi, everyone. Sorry, we had to connect a different computer back here in the training room. So if you are all still here, you can put your cameras on so we can see you. So hi, Pat West.
Hi, guys.
So Pat's here. He is going to be, hi, everybody. So Pat is longtime agent, an investor here at the office as well. So Pat's a really great one to learn from. So I am going to share the screen to pull up the purchase contract. That way you all can see it as Pat goes through it. This is not working.
What? Well, we don't need
Yeah,
it.
just, yeah, that's fine. Sorry, guys, bear with me one hot second here.
You just have to stand up.
Yeah, so Pat, you'll just want to come over here. Okay. Okay, so we are screen sharing. Okay.
If you're going to
Yeah.
be here.
I mean, I'll be in my office, but I can hang around for a minute to make sure that you are good to go.
Can I, as long as I can scroll through the contract?
Yeah. Yeah. Okay.
Is our microphone? Can you guys hear me?
Yes.
Okay.
Okay.
Thank you. All right, and I'll turn up your volume too. I don't know, this is not my, oh, here we go.
Oh, look what we got.
Yay.
Hey,
Yeah,
a purchase
definitely
contract. Look at that.
do.
Woohoo.
Yay, okay. Okay, Pat, so all you'll want to do is just scroll through this contract.
Okay.
Okay,
Got it.
and it's a 2-finger scroll.
Yep. Got it.
Okay.
Yep.
All right, Pat's in charge.
Oh, that's scary. Okay, guys, we need to go through this actually pretty quick because this, as Mark Sullivan is here and told me, this is a 3-hour class at the board or at Columbus Realtors, which I know it easily could be. I want to go through real quick and have everybody introduce themselves real fast, who you are, how long you've been in the business, and just have you written a lot of contracts or have you never written one? So, no, I'm all right.
Sure, it's gonna be a long hour.
Go ahead and whoever wants to start. Tammy Hoffer, if I mess up your
yes.
name, sorry.
Yep, I'm here.
Go ahead. Tammy.
Tammy Hoffer. I've been in the business here in Ohio now for almost a year, and I have written a few, not a lot of these, so a few.
Awesome. Awesome. Good deal. Okay, Kimberly Marie.
Hi there, my name is Kimberly and I've been licensed for a few months now and I've yet to write a contract.
Okay, good.
Coming soon, girl.
And Sybil Harris.
Hi, so I've been
ahead.
licensed just about a year. Can you hear me?
Yeah, go ahead.
Can you hear me? Okay,
Yeah.
hi, I've been licensed about a year and I've written about 5 or 6.
Oh, good. Okay, good. All right. We're trying to get to the screen.
Casey,
Casey, go ahead.
you're muted.
Unmute yourself,
Me?
Casey. Go ahead.
Yeah, that might help. Hey, Casey Valentine. I've been at Keller Williams 5 months now. Previously, I was licensed in the state of Washington and wrote several contracts out there. However, the contracts are different here in Ohio. I haven't written any in Ohio, but I've received a few. So looking forward to this class. Thanks.
Okay, good. All right, good. Stella, go ahead.
Hey everyone, Stella Stevenson. I been licensed for only 70 days and I have not written a contract yet. So I'm excited for this class. Thank you.
Great.
Awesome. And Chelsea?
Hi, I'm Chelsea. I've been licensed for just over a month now. I have yet to write a contract.
Awesome. Okay, and Julie Gale?
Hi, I have been licensed for just a couple months now. I have not written a contract yet, so I'm looking forward to the class.
Okay, awesome. Brett Royer, go ahead, Brett.
Hey, my name's Brett. I've been licensed since late July, and I think I've written 4 or 5 contracts so far.
Awesome, good deal. And Josie Lawyer?
I've had my license for about a year, and I've written 4 contracts. 3 were for one client, and one for.
Awesome, awesome. Okay, did I miss anybody? Because I'm having a hard time with the screen here. We didn't miss anybody?
I think we're good.
I think we're good. All right, awesome. That's good. So I am going to go through this again real quick. If you have questions, I'll give you my contact information. I also have Noelle Luzio, who is here. Morning. It's kind of slow. Noelle is my administrative assistant, and she's the one that actually does all the work, and she's phenomenal. I brought her here to share some insights with her, for her to share some insights with you about what she does and how we handle our business. I have been in the business 31 years as, we'll call you. Okay. I do a fair amount of residential and quite a bit of commercial real estate. And as Andrea said, I am an investor in the brokerage here. So I want to go ahead and dive right in. Our purchase contract when I started was only 2 pages. It was a legal page, front and back, and only about half the back of the page was actually a purchase contract. So it was blank. Front page was full, back half was about half full. Now we have 14 pages of purchase contract, and the reason for that is basically for as times change and lawsuits happen, they update the contract. We have one of the best purchase contracts in the country. I've been to other states and to family reunion and other different events and talk to other agents, and it's extremely comprehensive. It's not foolproof, nothing is, but we have most of the stuff in our purchase contract that really makes you not have to think, just fill in the blank. But anyway, to start out on the first page, at the very top, you'll see where it discloses, it talks about the different typefaces in here. So our standard contract, all of the pre-printed stuff is in one typeface. If you're going to make changes to the contract, to the body of the contract, it tells you it needs to be in 12-point or larger. Do you need me? There's nobody here, all on Zoom. Thank you. 12-point or large Courier font in bold. So if you guys are looking at this, I'm assuming you can all see my screen. Next, they talk about, if you look to the right top corner there, they talk about adopted by Columbus Realtors and CBA, which is Columbus Bar Association. So over the past, I don't know how many years, it's been more than 30 because it's been like this since I started. So probably the last 40 or 50 years, Columbus Realtors and the Columbus Bar Association have worked together to create this purchase contract that we have now and all the changes over time. The right below there, it says it's recommended all parties be represented by a realtor and an attorney. I am one who is very adamant that you should discuss with your client up front if they want to have an attorney. I'm frozen. Can you guys, can someone unmute themselves? Can you still hear me even though the screen looks frozen to me?
Yeah, you're fine.
I'm sorry, guys. Okay, so if you know a real estate attorney, if you don't, you can talk to Dela or any of the staff, or talk to, if you're on a team, obviously talk to your team leader and so on, about attorneys you can refer to clients. It's always good to have that. God, this thing is terrible. Okay, so in the body of the contract, the first thing obviously is the date. Anybody can figure that out. And then it starts it says, upon the following terms, the undersigned buyer agrees to buy and the undersigned seller agrees to sell through the broker referred to below, the premises described as being located in the state of Ohio, county of whatever county you're working in. You know, we mostly work in Franklin, Licking, Delaware, Fairfield. There's a few other counties that we work in, but obviously make sure, even if you read an MLS, it says double check the county and the parcel number. The next blank is the parcel number. I always recommend, if you're going to write a purchase contract, that you pull up the property address in the county auditor and pull the auditor's sheet and take the information off that. It's very easy for someone to make a keystroke mistake and have MLS information not be correct. You want to make sure, because this is principally dictating what the buyer is attempting to purchase. And then obviously, and further described as, most attorneys recommend that you just put the address of the property in. If you get a little bit more experience and time, you can do, you can explain, you know, if it's what it is, how many acres, if it's land and out, you know, not a regular residential. But for now, I would just put the existing physical street address of the property. Obviously, in the next line on 1, it's the purchase price of the property. And I always highly recommend that you type out the number, and then in parentheses and all caps, you'll type out the amount. You'll, you know,
like spell out
200,000. Yes, yeah, $200,000 typed out in numeric form, and then put in parentheses in all caps, but $200,000, or obviously whatever the number is. Additional terms and conditions. This is for any additional information, a contingency, I would say a home sale contingency. In this market, we're not doing that, but appraisal, you know, there's appraisal gap coverage. There's a lot of different things that we can put in here. The attorney approval clause. This is a big one. This is a big one for me. I have a real pet peeve about this. I get contracts all the time that, is this frozen?
A little bit, it'll probably lag.
Okay. The number 2, the attorney approval clause. I absolutely recommend you never write a purchase contract without a number in this paragraph. And the reason for that is, this does not say the buyer or the seller has to have an attorney. This says the buyer or the seller can have an attorney. And real quick, you should discuss that with your client. Even if your client says, no, I don't think I want to have an attorney, you still put calendar days in here. 3, 5, 7, I don't, you know, depends on you know, when you're doing the contract and many variables, but I would say an average is probably around 5 days. It's calendar days, so obviously if the attorney doesn't work on Saturday and Sunday, you have to factor that in. If you have a great relationship with an attorney that'll work on weekends for you, that can be, you can figure that out. But this contract says in it that the buyer and the seller, or the seller, can have legal representation. You always want to do that. I can't hit that hard enough. And the reason for that is, if anything ever happens and someone goes back and looks at the contract, says, well, you didn't even give the provision for the buyer to have an attorney, which if you put a number in there, obviously you did. Okay, financing. We're going to talk about financing. The most important part about this is, hi, Rach. When you're writing a purchase contract, I always have agents ask me, how many days should I put in there? What should I write in here? And you don't fill out the purchase contract, in my opinion, until you have spoken with the buyer's LO, loan originator, and in great detail. And you have obviously a lender letter, a pre-approval or a pre-qualification letter. You do not want to fill this out until you've actually talked to them. Timeframes matter, and the lenders are one of the most important here. Without money, you don't have a closing. So on 3.1, under paragraph 3, this is if your buyer is going to purchase in cash. If it's a cash buyer, you'll read it 2 initial blanks. Buyer will pay the purchase price in cash at closing. And then it goes on to say paragraph 3.2 does not apply to this contract if you fill this part out. Buyer shall deliver to the seller or seller's broker within X calendar days. You should have, and this is for after the acceptance of this contract, a letter from a financial institution, current bank statement, or other evidence of reasonably satisfactory to the seller that sufficient funds are available. So you'll want to have a funds verification letter of some kind to give to the to supply with the purchase contract. If your buyer, this is only if your buyer is doing cash. If your buyer's financing, then you go to section 3.2, which is the next paragraph down. And just one person chime in. Is everybody, can you see and hear me good? Can you see the contract?
Yes.
Yeah.
Thank you. Okay, 3.2. Now, your buyers would buyers would initial section 3.2 if they're doing a mortgage, which most will. This contract is contingent upon buyer obtaining financing for the purchase of the property subject to the provision set forth in paragraph 3.2. Now, A is a pre-qualification letter. I highly recommend that you already have your buyer pre-qualified, and that you, in this market, and most of you, I'm assuming, are doing this. You'll send the letter with the contract. It gives your buyer strength. But your buyer will initial has delivered or shall deliver. Obviously, has delivered, meaning it's supplied with the contract, is the ideal situation there. The next one is, oops, sorry guys. The next one is 3.2B. This is the loan application period. It says within blank calendar days, and it says if left blank, the number will be 7. You should, to be timely, I wouldn't want it to be any more than 7. But you need to make sure that your client can meet with the lender within the time period you put in here. So after the date of acceptance, and we'll go over what acceptance actually means here shortly, make a formal loan application for a conventional FHA, VA, or USDA. This is a critical component of the contract. You need to talk to the lender and find out what loan the buyer's doing before you write the contract, because you need to fill this out correctly. So the number of days to actually make formal loan application, and then the next under A there, it is what type of loan the buyer is going to do. And again, that'll come from the buyer's lender. And hopefully they will have chosen a lender and have most of this stuff done before. So right below that, it talks about inform the seller or seller's broker in writing the identity of the lender. You want to communicate with your co-oping agent. You want to give them as much information as you can. I'm going to show you something that we do that I think really helps that, but the contract is the key. And I want to talk about, so the contract is the script or movie script for the transaction. Whatever's in the contract is what's going to dictate what's going to happen throughout the entire transaction. So everything you put in here needs to be what it should be, so that the transaction can be smooth. And communication with all parties is critical to that. Your co-oping agent, your lender, your title people, and so on and so forth. And if you're writing, your buyers, sellers, your clients should all be included. So so you need to, now in the rest of this paragraph here is talking about if the buyer fails to do what they're supposed to do. Failure of the buyer to deliver the lender's written notification within 3 calendar days following the buyer's receipt thereof constitutes a waiver of the buyer's rights to terminate the contract due to the buyer's failure to obtain financing. So all that's saying is that you have to put your timeframes in and meet your timeframes, and be very cognizant of all of that, because it is very important. Loan commitment, again, this is something you'll discuss with your lender or with your buyer's lender. And you want to put a number in here that you know they can meet. So sometimes if the buyer has all their stuff done, it can be 30 days. If it's not done, it might be 40, it could be 45, depending on the type of loan, how busy they are, how backed up appraisers are, so on and so forth. But that's a discussion to have with the buyer and the buyer's lender prior to writing the contract. 3.2D is the, am I doing this wrong? So 3.2D is the appraisal contingency. This is not applicable if the buyer's doing a cash transaction. It says in the cash transaction that this doesn't apply. Now, if your buyer's doing a cash transaction and wants to have an appraisal and make it, you have to write in and make it a contingency in the contract. I hope everyone's understands what I'm saying there. If you don't, let me know, but that's important. So if you're doing a conventional FHAV or USDA loan, this is already built into the contract. The contract is contingent upon the appraisal. You can read the language, and it tells you that it's a part of the contract, and it's a contingency. Now, if you scroll down to the next, if you guys are looking at the purchase contract, paragraph 3.3, which is at the top of page 3 of 14, demand for financing evidence. This was put in, I don't know, maybe 6 or 7 years ago, I think it was. This is if you're the seller's agent and you're not getting response from the buyer's agent or the buyer's lender, and they have not done what they're supposed to do. This is a provision
Is he completely frozen and silent for anybody else?
Yes.
Yes.
Yep.
Okay. Well, okay then.
Are we all still frozen?
Yes.
Yes, we
Okay,
are.
just checking.
I'm trying.
Yep.
Hey, guys, he's back.
Can you hear me?
Yes.
I apologize. We're having serious technical difficulties here. We were on, take me back to the screen share. All right.
Here you go, friend.
Okay.
There you go.
Thank
Exactly
you.
where we left off.
I apologize again, guys. Okay. So section 4, we're talking about taxes and assessments. So it says right there, if you read in paragraph 4 under section E, it says a portion of such taxes and community development charges for the year of closing shall be prorated through the date of closing based on a 365-day year. You can calculate those numbers, but the title company will do it for you. I always recommend that the agent be on your game and you calculate it yourself. Make sure that the tax proration credit is what they have, and then if it's not, then ask questions or bring someone in that can fix it. Now, when it talks about assessments, the assessments would be for the seller unless otherwise negotiated in a contract. If there's an assessment on the property, and I'll give you one of many examples, in a lot of older subdivisions, they'll have sidewalk programs where the city or the county or the township or whatever will come through and they will put in repair sidewalks and curbs and street approaches and that kind of stuff. And then if the people don't want it, the owners don't want to pay for it, they can amortize those charges in their property taxes. Generally, it's over 20 years, but it doesn't have to be. Anyway, if there's an assessment recorded on the property, then if it's not negotiated in a contract, this portion of the contract here says that all taxes and assessments will be paid at closing. So if there is an assessment out there and the seller's agent hasn't done their homework and the seller gets to closing and there's a $10,000 assessment payoff on there, it is what it is. So be aware of that if you're listing a house, but also be aware of it for your buyers. A lot of times if there's an assessment outstanding, the seller's agent will negotiate with, the buyer and the seller will negotiate and they can keep that in their taxes or whatever the negotiation prevails. So it talks about, again, about agricultural use tax recoupments for years prior to the year of closing. They go back 3 years. You guys, unless you're selling raw land, you should not have to deal with those on a regular residential transaction. It's just going to be the tax proration credit because the agricultural tax recoupments would have been done when the subdivisions were put in and already calculated. So Is there anybody, any questions? I know this is complicated. Does anybody have any quick questions on taxes and assessments?
Do we put any type of note in there to say that the seller would cover that if they're unknown, like so they don't pop up on us on the buyer side?
So if you have a seller that has an assessment on their property,
Yes. And that wasn't caught, like you said, sometimes the listing agent won't catch it.
so what would happen is if I was a buyer's agent, you had the listing and it had an assessment on it, I would send you a contract, and then you would counter back to me saying, there's an assessment on the property of an outstanding balance of, let's just say $8,000, and the buyer agrees to continue paying that in their property taxes, and it won't be paid off at closing, and language to that effect. Does that answer what you were asking?
Yeah, I guess that's just, it sounds like it's a negotiable thing then.
Well, it can be, yes. In this market, nothing's really negotiable because the sellers have all the power in a moment. But yes, in a normal market, it is negotiable. But my higher point on this is, if the seller's agent, or if you are the seller's agent, you need to make sure you know that, so that when you get an offer that you can counter it, or else you're going to commit your seller to paying it off if you don't catch it, because the contract says in here it will be paid at full at closing.
Okay, by the seller.
By the seller, correct.
Okay, all right.
And then community development charges, you won't see those very many. It's pretty rare to see a community development charge in there. Once in a while, again, that's would be covered. It's would be paid at closing and by the seller if it's not otherwise notated in the contract. And then 4.3 talks about seller warrants: no improvements or services have been installed or furnished, nor notification received from a public authority for future improvements, which may be a part of cost, may be assessed against the premises. So just an example there, again, I use the sidewalk assessment because it's reasonably common. If your seller has received a notice that they're going to be doing a sidewalk program, then they have to disclose that to the buyer, even if the work hasn't been done yet. Fixtures and equipment on 5. This has been updated over time and now has quite a bit of information on here. You need to read through this and be familiar with everything on there. These are the things that the consideration shall include: all fixtures owned by the, sorry, shit. Including but not limited to all of these items. Now, if there's 2 things on here that you need to be aware of, you read all through this, and if there's anything else, then you want to include that. There's leased items. If you go down a little bit, yeah. If there's any leased items, a good example of leased items would be security system. The electric company used to do hot water tanks. They used to lease hot water tanks to people. I don't know if any of you guys have seen that or not. There's a few other examples, but leased items obviously can't be conveyed because they don't own it. Water softening equipment a lot of times is leased. There's a few other examples, but that would have to be under 5. You put that under 5.3. It's excluded from the contract because obviously the seller can't sell something to a buyer that they don't own. If it's leased, they don't own it. So all of the included items, and including the following, so that generally in there you would have your refrigerator, range, microwave, dishwasher, anything else in there that other than chattel. And a big thing here is personal property or chattel can't be put in there because the buyer's lender will kick it out. Because yeah, flat screen TVs and all of those things. If that's going to be negotiated, that needs to be negotiated outside of outside of the contract. And then in 5.2, it's items that are excluded. Did somebody have a question? No questions? Okay. This is really important. You want to make sure you don't commit your seller to selling something they can or can't sell. So making a list, if you have the seller, if you're the buyer, you can ask for anything. It's up to the seller's agent to say, hey, we can't do that. Okay. Number 6, this is one of the more important parts of the contract, in my opinion. The inspection clause in the contract. I know that in the current market, a lot of people are doing contracts with no inspections. And you have to discuss that at length with your buyer. That's a very dangerous thing to do. And in some cases, if your buyer wants a house bad enough, they may have to make an offer without an inspection included. I do not recommend that. I can't say it strong enough, but because A, sellers may or may not tell the truth on the RPD, and B, there may be things about the house the seller actually doesn't know about, and your buyer may discover it after the fact, and that can be a big problem. So 6.6, paragraph 6, 6.1, it just says, brokers, we strongly recommend that you have an inspection test done by a licensed state of Ohio inspector. And then in bold, right below that paragraph, it says that it's not the intent of this provision to permit the buyer to terminate this agreement for cosmetic or non-pure conditions. So that's a really important point. If your buyer does a home inspection and they say, look, we don't want to buy the house, and they basically get cold feet, you can't say, we don't like the color of the living room, right? So it has to be something significant that they didn't know that was uncovered. So the overarching point here, don't have your buyer sign a contract unless they're absolutely committed to buying it. And I tell people, once you sign this, if the seller signs it, you're buying it.
I got a question real quick.
Go right ahead, fire away.
So on this, is it okay to still, put in there in some language that, hey, we're going to waive any inspection remedies, but we still want to get an inspection, but do not anticipate asking for repairs?
Yes, you can do that. Yes, and I'll show you how here in a second. There's multiple ways to do it. You can actually put the language in the body of the contract or an addendum or whatever. A lot of agents are, there's one important note underneath where it says this provision is not to permit the buyer to terminate for cosmetic or non-pure conditions. It says buyer shall be responsible for any repair or any damages caused by the buyer's inspections and tests. So if your buyer hires an inspector and he breaks something, your buyer's on the hook for that. Make sure you understand that. Then the seller shall cooperate in making the property reasonably available for the inspections and tests. Okay, so your question was about inspections but not remedies. So in our paragraph, the way it's built, 6.3 is specified inspection period. This is the period of time your buyer has to do any or all of their inspections. And that, that can be as a general home inspection. It can be a termite inspection. It can be radon, you name it, any inspection, and they're all listed, and you can do anything you want. If you scroll down and look at section 6.4, this is agreement to remedy period. What a lot of agents do is they'll put 5 or 7 or 10 days in the inspection period and put 0 where it says the buyer shall have 0 calendar days. This negates your buyer the ability to request remedy for the inspection. So if they find something, they can still terminate the contract based on the inspection, but they can't request a remedy to that. Does that make sense to everybody? Anybody got a question about it? Something wrong?
No, that makes sense.
Now, you can also put language in the contract if you want to clarify that, because quite frankly, most agents don't know what the contract says. But if you put in your time period for the specified inspection period and put 0 in the remedy period, you've effectively done what you just said. So it's, in my opinion, and I know this is a tough market for buyers, I get it. I would never buy a house without inspecting it. And I've bought and sold a lot of houses. Other things like you can see all of the different inspections in here: radon, mold, lead-based paint. Lead-based paint, I'm sure everybody knows, is prior to January 1st, 1978. Yeah, I've only done a small handful of lead-based paint tests in 31 years, but I have had them done, and they're, you know, it's up to your buyer. But in this market, guys, I apologize, but it's really a seller's market, so we're kind of limited. But I would still recommend the buyer does an inspection. And if they don't get the house, there'll be another one that comes along. Then 6.4 talks about if the buyer's not in good faith, satisfied with the condition of the premises, that gives them the ability to terminate. And then 6.4a, in a normal contract, your inspection period might be 10 days and your specified inspection period might be 5 days. So you get you get back your inspection, you go over it with your buyer, you and your buyer decide, hey, these are the most important things. And there's a form that's called in our library called Buyer's Request a Remedy. So you would get the Buyer's Request Remedy, you'd fill that out, provide the Buyer's Request a Remedy and the inspection, the full inspection, to the seller's agent to request those items to be repaired, and then you would negotiate from there. Everybody clear on that?
Yes.
Okay. Oh, there it is. On here, okay. If you look down here on page 6 of 14, it gives you the different scenarios that I just discussed. 6.4b is notice of termination. There's a form, notice of termination, and a little thing that I'm going to say to you guys. If you're doing a notice of termination, do a mutual release at the same time, and don't listen to agents that tell you, oh, you don't need a mutual release because there's no earnest money. Please, a mutual release is exactly what it says. If you terminate a contract, that is a single sheet form that you fill out why they're terminating, and the buyer only signs that. On the mutual release, your buyer signs it, send it over to the seller, and the seller signs it. Then everybody is mutually released from the transaction. There's no discrepancy. Anything happens down the road, you've checked all the boxes.
Everybody signed.
Yep. Belt and suspenders is what I call it, because I'm old and that's what we used to call it. Failure of the buyer to deliver the written notice pursuant to the paragraph 6.4a or b constitutes acceptance of the condition. So in other words, if you don't do anything inside, so let's say it was a 10-day inspection period, if you do not submit something to the seller or the seller's agent within the time period you specified, you've waived the buyer's rights to do so. And I want to make sure everybody understands that. Is anybody unclear on that? Okay. We're gonna go on to 6.5. This is condominiums or document provision. This used to be just a separate form, and this is brand new. They've put most of the things in here. If you list a home, or if you have a buyer and you're writing a purchase contract, most of the newer subdivisions will have a homeowners association. And if you have a condominium, by sheer definition, you will have either a management company or you will have a condominium association. So this talks about a condo's declaration pages, deed restrictions, bylaws, owners association information. One of the most important things, you want to check if you're writing a contract on a condominium, you want to get from the listing agent, or if you can't get it from the listing agent, from the homeowners association, the condo association, the financials of the condo association. You want to know what your buyer's getting themselves into. You want to find out how much reserves they have, what the fees are, how it's managed, what the expenses are, and so on and so forth. This is a big responsibility for a buyer's agent. And most agents don't take the time to do it. But if you're representing your client, I think it's very important that that you do that. So if you read through here, it'll talk about association initiation fee, reserve contribution, association transfer fee, all the different fees. And you want to see a year or 2 or 3 of statements on what the association took in and what their expenses were. And they should have a projection of expenses for the association. And every condo association is different. I have my mom lives in a condo that I sold her in 1991, and I'm going to give you this real quick. There's probably, I think there's 20 buildings. They're quads, four units to a building, and 19 are on one side of the street and 1 is on the other side of the street. When they did the legal for that, it's its own separate association. So don't ever assume, if you guys have ever heard if you assume something, you make a, you know what, out of you and me. Never assume. So you want to find out who the association is, how many units are in the association, and the other information. That's very important when you're dealing with condos, especially. Homeowners associations are a little less, I don't want to say less important, but generally they don't have the expenses that a condo association would have, and so on. So 6.5B talks about your review period. You have to get the information from the seller and or seller's agent or from the management company or so on. And then your buyer has X amount of time to review. Make sure you read this carefully. And I don't have time to read through everything on here because it's of time constraints. But you want to read through this carefully and understand that your buyer has an obligation. Once they get the information or you get it, you have to sit down with them and go through this information and make sure they understand and they're okay with it. If you don't, again, if the time elapses, then you've forfeited that opportunity for the buyer to address it. Paragraph 7.1 is a home warranty or protection plan. I'm assuming most of you have or affiliation with some homeowners association, home warranty or protection plan that you use or that your team lead uses, or if you have questions on that, anybody here can help you. If you're working for a buyer in this market, again, is very different than past markets. You may or may not include this. I always include it. There's a lot of liability here that is deflected. It's not gone, but it's deflected. If, for example, your buyer does not do an inspection and something comes up 3 months after they move in and you have a home warranty for them, this doesn't solve the problem, but it certainly helps. Say the furnace goes out and they need a new furnace. This is going to be, should be a deductible or a small expense versus being a catastrophic expense, and more importantly, possibly a lawsuit and liability. So I think it's important to have a good home warranty plan and understand it, be very comprehensive and understand the plan, and explain it carefully to your buyers so they understand if you can get it accepted. All right, deed. Any questions on anything I've gone over? Am I going too fast or is it okay?
Good.
Anyone? Good. All right, we're on paragraph 8, deed. So a deed transfers or conveys ownership. Well, you'll have old people if you deal with them, and I'm not making fun of old people because I am one. They'll say, I got my deed, I got my deed. It's relatively worthless after it's recorded. What the deed does is it says the seller shall convey to buyer marketable title and fee simple by transferable and recordable general warranty deed with release of dower, if any, fiduciary deed as appropriate, free and clear of all liens and encumbrances not accepted by this contract, and except for the following. So what all this is saying is that the seller is going to have, it's an attorney that prepares it, a deed to convey ownership from the owning entity, whether that's a person or a trust or an LLC or whatever. Generally, it's going to be a person's name or a couple's name. And then that will transfer it to if you're writing a contract, to the buyer. you want to review it, because if there's deed restrictions, we'll go over the title work here in a second, but you want to make sure there's no, because a deed can transfer the ownership, but there could be deed restrictions, and that could restrict some of the potential uses or things that the buyer can do with the property. In a regular subdivision, again, it's mostly boilerplate title, and there's really very little of that other than the deed restrictions, like fencing and sheds and different things like that. But it's mostly boilerplate. But if you get out and you do a rural contract, there can be deed restrictions. And my goodness, we could have a whole 3-day class on deed restrictions, but you want to review the title work and be aware of that. So 8.1, it says the seller is going to prepare that and transfer it. And then this 8.2 says the seller has not transferred, conveyed, or reserved, nor does the seller have any knowledge of prior transfers, conveyances, or reservations of any coal, oil, gas, or other mineral rights. Mineral rights is a whole nother can of worms. If you want to do you would have to do a title search. It's a special search. It goes back, I forget how many years. I think it's 50 years, I believe. I'm not sure about that. It would be, it's a reasonably expensive search to find out if there's any oil or gas or mineral rights on the property and if they've been conveyed. Again, if you're in a regular subdivision, that's probably not ever going to come into play. But if you're out in rural areas where there's land, and quite frankly, the more east of here you go, there is a lot of oil and gas out there, and you could run into this. If you do, again, you want to talk to an attorney and at least a title attorney, and then if not a gas or mineral rights lawyer. All right, number 9, title insurance. This says our contract, and again, our contract speaks specifically to Central Columbus in our market. The seller shall furnish and pay for an Alta homeowners commitment and policy of title insurance, latest version, in the amount of the purchase price. So the seller is going to pay for the homeowner's title policy. Now, what happens is when you get an agreed upon purchase contract, the lender, the title, the buyer and the seller, and the agents, everyone gets a copy of the contract. The title company will order a title search, and they will do the search. And then from that search, if there's, depending on if something comes up or not, they will convey the title to the buyer at closing, and will give them a title policy. So title insurance is, for lack of a better term, it's like car insurance. It's insuring the title on your home. So if you sell a house, and I've had this happen, 3 years later or 2 years later, someone comes knocking on your buyer's door and says, hey, my uncle sold this house and I had an interest in this property and I was never compensated for it, or I didn't sign off and sell it. That's when the title insurance would kick in and defend the title policy that was delivered. So I know that's pretty complicated and off the beaten path, but you have to understand what title insurance is and why it's there. Very, very rare. It happens. It doesn't happen very often. But you want to be aware. And what I tell people is, when we get down a little further, it'll talk about title policy and commitment. And you want to read the title commitment. You want to understand what it says. And if you're newer and you've never done that, that's fine. But you need to go, if you have your own title agent that you use, or the title agent that the seller is using, because generally the seller picks the title company, you would want to go to that company and say, hey, can I sit down with someone, a licensed title agent and or an attorney, and go over this and understand title commitment A and commitment B in the title commitment. Because that's, if there's provisions in there or exceptions, you want to understand that so that you can explain it to your buyer. Anybody have any questions on that? Okay. We're good? All right. The so it says here at the very bottom of page 7, the title evidence shall be certified within 30 calendar days prior to closing with endorsement as of 8 a.m. on the business day prior to the date of closing, all in accordance with Columbus Bar Association standards. That's saying that the title evidence is going to be prepared, or a title commitment is what it's generally called. And 9.2 says the seller shall deliver or cause to be delivered to the buyer or buyer's broker a copy of the commitment referenced in 9.1 above no later than 15 days prior to the date of the closing. And the reason for that is, again, so that you and your client can go over the title commitment. And again, if you don't understand it, you get a title agent involved or an attorney, a title attorney preferably, to review that so that your client understands. Generally, there's nothing there to worry about. It talks about tax proration credit. It talks about if there's a mortgage or a mortgage and a HELOC, or it'll itemize those things that need to be addressed at the closing, which is normal and fine. But if there's things on there other than that, then you need to make sure you understand it and you go over it with your buyer, and they understand it, which is most important. And then it says 9.3, it says buyer may object if the commitment indicates that title to all or part of the premises is unmarketable or determined by Ohio law with reference to Ohio Bar Association standards of title examination, or if in good faith objects encumbrances, easements, conditions, restrictions, conveyances, or encroachments that are disclosed in or accepted by the title, by the commitment. And then it goes on to explain more things. Again, we could do an entire class on title and title commitment. This is just something that you guys need to read through this. And I would recommend that you read through the whole contract and then take a highlighter and then make notes of your questions, and then sit down with either one of the Mark the broker, or a more experienced agent. If you're on a team, again, your team lead hopefully will know all this stuff, and so on. And then make sure you understand it, because when you're sitting in front of a client, and I know we don't do that very often anymore, we do these Zoom things, but if a client asks a question, you sure as hell want to know what you're talking about. Any questions on that? Okay. The seller pays for the title insurance policy, but it says in 9.4, if required by the buyer's lender, the buyer shall pay any expense incurred with connection with the mortgage title insurance issued to protection of the lender. The lender will absolutely be protected, and the buyer will pay for that. Used to be $100. I think it's between 150 and 200 now. Your buyer will pay that, and that should be disclosed when the your buyer's lender goes over their disclosure with them. That should be. And it says 9.5, at closing, the seller shall sign and deliver the buyer and title insurer an affidavit with respect to off-record title matters in accordance with the community customs. So number 10, is there any questions on any of this? Title is a big, big, big thing. Okay. Number 10, this only pertains to a property if your buyer's buying a property and that property is rented. If it's owner occupied, paragraph 10 does not apply. So what this talks about is interest, rentals, security deposits, utility charges, all of those things will be security deposit transferred to the buyer, and so on and so forth. It's very important to know that for a whole lot of reasons, but one of the most important is for possession. If your buyer's buying the property, they have to take possession within 60 days, or the loan is no longer a owner occupant loan. It would now become an investment loan, and down payment, interest rate, and all of the terms are completely different. Any questions on 10? section. Anybody that has a question, jump in if I going too fast. Paragraph 11 talks about damage or destruction of the premises. What happens on this is, I call this the no man's land clause. It actually happened to me when I bought my first house 32 years ago. When your buyer buys a house, say they do a home inspection, everything's fine. You're doing your walkthrough the day before closing. That night there's a storm, a bad storm, high winds, rain, sleet, snow, whatever. A tree falls on the house, and you either catch it before closing or you catch it after you close. If it happens before closing, this is a provision that protects the buyer from damage to the property after the inspection, but before the closing. So if any of the premises is damaged, this gives you the remedies for whatever the scenario is. In my case, it happened a few days before closing. A tree fell on the garage, knocked a gutter off, damaged a few shingles. The seller cut me a check for, back then it was a few $100 or something, and I put the gutter back up myself and fixed the shingles, and we all agreed and it was fine. But the key point to this is, if something happens, the seller is required to disclose. And again, this is another reason why we do walkthroughs, to make sure that that didn't happen, and that we don't go to closing and haven't seen the property in 2 or 3 weeks, and all of a sudden, hey, buyer goes to get to their new house and there's damage, and it's a much bigger problem at that point. This gives you all the different scenarios. They can terminate the contract, they can get an insurance check, they can settle financially with the buyer or with the seller. But it does say in 11.3, failure of the buyer to notify the seller or seller's broker in writing within calendar days from receipt of the notice, or damage or destruction that buyer is electing to proceed. This says if the seller notifies them and the buyer doesn't respond, they're accepting the condition in effect. And failure of the seller to provide required written notice to the buyer is on the seller, but it's important to know that that's in the contract. Any questions on damage or destruction? What time is it? It's
not
okay. I'm gone over a little bit. If anybody has to leave, go ahead and leave. I apologize. I'm trying to go as fast as I can. Earnest money deposit. The most important thing about earnest money is that you properly insert it in the contract. Your buyers initial the correct language in here. If it's within 3 days of acceptance of the contract, or if it's within 3 calendar days after the expiration of the agreement to remedy period, make sure the correct paragraph is initialed and that the correct amount is inserted up the top there. And that the receipt is delivered to the other. So if you have a buyer, your buyer right gives you a earnest money check, you deposit it here at the brokerage. You want to send notification to the seller's agent that you collected it, and then it's been received. You want to make sure that you don't forget to collect it. If you write it in, that is a major violation, and you want to be very careful about that. And then you want to make sure that you follow everything in here. Yeah, make sure you turn it into the broker in a timely manner. Don't wait till the day before closing and then tell them you need this for closing tomorrow. Turn it in quickly as it says in there. And then obviously make sure that the earnest money is made out to the brokerage. It's obviously not made out to you, the agent. Keller Williams Greater Columbus Realty, and then installed, and then sign the contract and send that to your co-oping agent. There's a lot in here about earnest money. Go ahead and read through that. If you have any questions, let us know.
Loading.
Hang on, the screen's loading. I apologize. Any questions on earnest money, guys? Okay. 13. These are basically just telling you, saying this contract constitutes the entire agreement. There are no representations or written which have not been incorporated herein. So this says, if you've written a contract and the buyer and seller have agreed to it, there wasn't a handshake that says the seller's going to do something after closing, or it has to be written into the contract. Time is of the essence regarding all the provisions. That's a very important component in this. Everything is outlined time-wise in the contract. You need to meet those timelines. It's very important that you do that. All representations, covenants, and warranties shall survive the closing. Term definition, broker and agent are often intertwined. There are specific times when broker is different than agent, and you need to be very aware of that, and your client needs to be very aware of that. Signatures, manual, electronic, PDF, e-sign signatures are all binding contractually. Most title companies still need wet signatures at closing that to be notarized, and then obviously recorded for the appropriate documents. The date of acceptance, this is a gigantic one that most people don't get. The date of acceptance of the contract, counteroffers, amendments, modifications thereto shall be when the final writing signed by the parties is delivered to the offering party. You guys got to read that 10 times and understand it. You are not in contract until everyone has signed the contract and everyone has a signed copy of the contract, has received it. When the offering party receives the signed contract back, that's when you're in contract. Make sure you don't get a counter offer, have your buyer sign it. Oh, we're in contract. You've got to share that back with the other agent so that you're actually technically in contract. And it says here, it is strongly recommended that the delivering party verify that delivery has been received by the other party. Please confirm receipt and get the confirmation. And I do that all the time and I drive people nuts, but it's for a reason. Foreign Investments, Real Property Tax Act. If you have a foreign person, which now we have to deal with this, if the seller is a foreign person as defined by the Foreign Investment Real Property Act, then you need to you have to get the identification and all the filings. That would, if you're working with the buyer, that's something that the lender is going to do for the loan, but you want to make sure you understand and have copies of all that, or else they can't get a loan. It says buyer and seller are advised to determine whether the seller is a foreign person as defined by the FIRPTA as soon as possible. So again, that goes to your due diligence as soon as you're working with your client. So many docs. Professional advice and assistance. This just says that agents and brokers have general knowledge in many fields. If your buyer or seller want tax information, they would talk to an accountant or a tax person. If they want financing information, a lender, surveying, a surveyor, structural conditions, someone who's certified structurally, engineer, hazardous materials, environmental conditions, and so on. They would want to talk to somebody specifically in that discipline, an expert. And we are not experts. We can advise, but this just is a CYA paragraph. Ohio Fair Housing, you guys should have all done fair housing. This just confirms that we're not going to treat anybody any different. Residential property disclosure form, again, with the docs, when you're writing a purchase contract, you want to make sure you have all the supporting documents that your buyer has reviewed and signed, whether that's lead-based paint if appropriate, almost always the property disclosure form with a very few exceptions, signed by all parties, and then any other documents that are required. You need to have those. I recommend you do not have the buyer sign the purchase contract until you've gotten the residential property disclosure form and had your buyer review it. Excuse me, you review it, and then the buyer reviews it and signs it. Sex offender registration notification law. This just gives your buyer the opportunity to see if there's any registered sex offenders in the area surrounding where they're buying a property. Most municipalities, this is on your sheriff's site. If you go there, there's an area for that. Not all, but most. If you have any questions about that, get help. Make sure that you're not selling a house to somebody next to a sex offender. Concessions. This just talks about the board's ability for data to MLS. You don't need to really worry about that, but your buyer has to understand it because they're going to sign the contract. Closing in possession. Again, the closing date is driven primarily by your buyer and their lender, but the lender, because if there's no money, there's no deal. So you would want to talk to your lender about all the other things we talked about and the closing date. Make sure they can make that date.
If the date changes.
And if the date changes, you need to, yeah, it says unless parties agree in writing to an extension. If you do it right and everybody's smooth, hopefully you'll write it with enough time that you don't have to do an extension, because that could put your buyer in a real bind if the seller says no to an extension. Final verification of condition, that's a buyer walkthrough. You would put however many calendar days. I usually put 2 or 3, just depends on the property and when we're closing. Possession, seller's entitled to possession through. One thing on here that I want to make clear, if the property's vacant or whatever days you, if it's possession through the date of closing, funding is very important. So you can actually have what we call a dry closing, means you close the document, you sign the documents, but if it's not funded, it's not closed. So if you have a seller, I recommend not giving the keys up until it's funded. So if you have questions about that, we can talk about it. Debris and personal property, this is for the seller. The seller is going to remove everything that's not included in the purchase contract, all their personal property and everything that's not written in. And the computer's, hang on, it's loading. Yeah, get there. Duration of the offer. Again, in a competitive bid situation, you'll want to read the agent's remarks. They may already have that in there, or whatever. If it's not in that type of situation, then you'll want to do that based on the conditions, the market conditions. This is the amount of time that the seller has to respond to your buyer's offer. Now, a giant, important, very important piece. This is the signature page of the last page, the signature page of the contract. You want to have their printed names on there. If you use .loop, it'll show their printed name. If you're doing a wet signature, I would either print clearly or type in the buyer's or seller's names so that it's clearly legible. That's valuable for all the people, lenders, title people, and so on. Admins. Then at the bottom here, something that's very important and is very often ignored. If you're writing a contract, and if you guys are using .loop or some other form, DocuSign, you can set up your purchase contract to preload all of your information on the buyer side. So your broker number, your broker license number, your office ID, all of this information, your license number, all of that information needs to be filled out. And what I do is we fill out the listing agent's information. All of it's available online either through Columbus Realtors or through the state of Ohio, the licensing division. But put all of this information, this should all be filled out. If there's an attorney, put the attorney's name and contact information. Fill this out completely. This makes the transaction smoother, much better. You will not get calls like, oh, what's your broker number? What's your license number? Everything better. Very, very important. The receipt of offer at the bottom. If you have a multiple offer situation, you can request that the listing agent have their seller sign saying that they received the offer that your buyer sent. In a competitive situation, this can be very important. Unscrupulous agents may not present your offer. That should never happen, but if it does, it could. You want to have this sign saying that the seller has received that offer. Couple other things real quick before I wrap up. I don't think you're gonna be able to read this. This is a document that we use. Probably can't read it. And this is a cover letter, and it has all of our timelines from the contract. We, as a group, deliver everything that cover letter's filled out with. It has the
Contract acceptance.
yep, it has the
purchase price.
sellers and buyers names up top. It talks about the group and CCing the admin and the agent. It talks about the contract acceptance date, final purchase price, any additional terms, pre-approval, earnest money, inspection, request a remedy, warranties, title commitment, final loan commitment, final walkthrough, closing date, possession, lender info, title info, co-oping agent info. This is all sent to everyone in the transaction. The co-oping agent, title, lender, clients, everybody gets a copy within 24 hours of acceptance. That's our standard. This cover letter goes over top of all the supporting signed documents. In order to have a smooth transaction, it's very important that you do something like that. That's pretty much it. I apologize for going over. It's 2:23. I have about 5 minutes. I can answer any questions anybody has.
Did you say that cover letter was a standard CBR document? Or are you
It is.
recommending that we include
It is
that?
not. I have Noelle here with me. If you can see her, she's my admin. We created that. It's our team thing. I think, I'm not sure. You can ask Dayla or Andrea or Rachel. There might be, I think there's a template in our documents on the intranet. I'm not 100% sure about that. If not, if you want someone to manage your transactions, which I highly recommend because you should be selling, not doing transaction work. Noelle does it for people if you want. She also does the social media stuff, but there should be a template in our documents. And if you have questions about that, somebody should be able to help you with that. If not, we can kind of give you a guideline of what you need to put on there.
Okay.
Anybody else have any questions?
None, but
I
thank
have
you.
one.
Go ahead.
So on I think it was in 14 where we were talking about possession. You know,
Okay.
what happens if, they want to close, say we wanted to close, December 31st, but they wanted to stay in the house until like February 1st. What do you do in that type of situation? I know there's a rent back type deal you can do, but I also know that I've heard now that sometimes sellers are almost expecting it as a concession. Like, yeah, you sold the house, but we want to stay in it for a month, almost kind of rent free. Is that something you've seen or?
Yes. The answer to that question is the market is so ridiculously hot for the sellers. They can almost, I don't want to say dictate, but it's almost dictating that yes, you can do a rent in normal markets. If the buyer and the seller agree, you can do a rent back. Now, in a hot buyer's market, the conditions might be a little bit different, but you can do, right now the seller's kind of dictating. So the buyer pays interest from the day of closing forward. So they're paying interest every day from the day of closing. And normally you can get, a week. Some agents will demand, sellers now are demanding, to have that for free. It used to be where if you wanted anything extended 30 days, you'd be paying for that as a seller. Now it's a negotiated item. And if it tips the hat, the one thing that I will be very caution you of, regardless of what you do on this, if on the purchase contract, if the lender gets it in the possession is more than 60 days after closing, the buyer, they'll kick it out because the buyer will then be classified as an investor, not as an owner occupant buyer, and all the terms will be changed. So on the purchase contract, it has to say that the buyer's taking possession within 60 days of closing.
At most.
Gotcha.
At most.
And is there a way to, is that provision about having a walkthrough before possession still cover you? So if you go through, 3 days before you take possession and they damaged a bunch of stuff, but you've already closed, like how are you protected in that situation?
It still reverts back, because if you remember, the contract says that all the provisions of this contract shall survive the closing.
Mhm.
So it would go back to the conditions clause that says normal wear and tear accepted, that the property be delivered to the buyer within, normal wear and tear accepted. If you're doing an extended delivery, I highly recommend that you put in, have an agreement signed saying, if it's, verbiage about condition and just strengthening or reiterating what the contract already says.
Okay, great. Thank you.
Yep. Anything else, guys? Nope. Was this helpful at all?
Yes, it was. Thank you.
Yes.
Very.
You're
Yes.
welcome.
So,
Yes, thank you.
Yep. All right. If you need anything, did my information show up anywhere, guys?
No, I don't think so.
Patrick West. I can give you my email. I'll try to give it slowly. Patrick West, one word, PATRICKWEST at West RE Group. That's WESTREGROUP.com. And if you're going to email me, please call me and let me know, or text me or something, so I know that you're going to do that. My phone number is 614-861-0394. Again, Patrick West, 614-861-0394. And I apologize for going so far over. I have a hard time doing this class within 1 hour. It's a 3-hour class at the board for a reason. It really should be 3 hours, because there's a lot to it, and there's a lot of variables that are very difficult to discuss. All right, I have to go pick up my daughter from school, so I'm going to sign off. And if you need anything, you know how to reach me. And if you need any information about our Noelle's admin services, please let me know that, and I'll get you her contact information. Thank you.
Thank you.
All right. Just close that up here. Good. Man, this thing is slow. Nick, go away. You got it. Yeah, just close that. No, it seems still there.